Mr Speaker, I'm standing to join my colleagues to speak on this bill, and it will come as no surprise that along with my colleagues and indeed the Māori Party, we are supporting this bill to Select Committee, but I also want to put on record that we see it as very important. This is one bill that is if ever the Select Committee process an example of how important it is. Indeed, Mr Speaker, I think this bill is a glowing example of that. We've heard, I think, that probably most of the reasons we hear from the government's side relating to support for this bill is about efficiency and haste, Mr Speaker. And we along with the Māori Party, do not accept that haste should be the top priority. And indeed, we have some really good examples of haste being used, or a hasty, efficient process in this House, Mr Speaker, that does not see justice served. And if we look at the 90-day sack at will bill that was pushed through under urgency and then extended under urgency in this House, if we look at the cutting of 4 weeks holiday, the abolishing of ECAN, the Auckland City legislation, all of those, one could certainly argue how efficient and how quick the process was, but it would be very hard to argue that also, certainly from our point of view and the majority of New Zealanders, that justice was served, and that we believe that what is paramount, certainly efficiency, and we commend any efficiency in the system, but we also have concerns because what must be paramount is for justice to be served, not just seen to be served, but to be served, and for all New Zealanders to have confidence in New Zealand's judicial system. So, Mr Speaker, some of the concerns, as we said, we will be voting for this bill, and we do want to acknowledge, Mr Speaker, that this was the result of the criminal procedure simplification project, which Labor, whilst in government, launched in 2007, was carried out by the Ministry of Justice, but also alongside the Law Commission. And the purpose of the bill was to set out the procedure for the conduct of criminal proceedings, allowing for electronic filing and management of the permanent court record, which is obviously very efficient. Now, I've heard other speakers say before me that this bill is some 526 pages, and I'd have to put on record that I haven't read all 526, but I know that the Select Committee is going to be receiving a lot of advice, and certainly very, very detailed submissions, and this will be a bill that will have to have very careful consideration, and certainly from Labor's point of view, we will have to give careful consideration and discussion within our caucus about some of the key concerns that we have, that my colleagues have already highlighted. Notwithstanding, one of our concerns is certainly that the Attorney-General, Christopher Finlayson, has released a scathing report on this bill, saying that it does contravene the Bill of Rights in many ways, and certainly by allowing, and this is one of the concerns that we have, criminal trials to proceed without the accused being present, and by allowing the courts to order the retrial of an acquitted defendant if new evidence comes to light. Now, Mr Speaker, I want to just put on record that when we undertook the Victims' Rights Inquiry when Labor was in government, one of the most compelling statements or parts of evidence that we heard from many victims was the anguish that, of course, they were already suffering if they had, when they had, in many instances, lost a very dear member of their family or friend, whatever the case may be, and then the complexity and the delays that happened during the court, during the trial, and many of those delays may have been justified, but in many instances it would appear that they weren't justified. So we certainly understand from what victims have told us how difficult that can be. But as we also want to see that that justice is served, that there is a fair process, and on one hand delivering a hasty process in the worst case scenario of the case of a defendant not having a proper trial in itself is a real concern. Other things that we will be carefully looking for, Mr. Speaker, is the threshold at jury trials and proceeding with 10 jurors that the bill allows currently to will allow jury trials to proceed on a routine basis with as few as 10 jurors. Now, in light of the most recent change to the threshold for jury trials, which Labor did support, this change is a further curtailment of the right to be trialled by jury, so that we hope that the government will carefully consider, and we want to put on record in this House that at the Select Committee that is something that we in Labor and indeed the Green Party who are opposing the bill will be listening very, very carefully to submissions. Other concerns were around the defence disclosure of issues, the requirement of the defence to identify and disclose any issues in dispute before a trial. We know that some in the profession have suggested that that would in effect be requiring the defence to help the prosecution build their case. So that is something that we will certainly be awaiting with interest the view of the legal profession and indeed other submitters apart from the legal profession at the Select Committee. The exceptions to the double jeopardy rule that this bill, as we all know, prevents people being tried again for an offence after being acquitted. Now that the bill provides that a person can be retried if new evidence comes to light, that is something that has to be carefully weighed up before deciding to overrules a really important provision, Mr. Speaker. Proceeding in when the defendant is absent. Now, this, and as I spoke about before, as victims said in the victims' rights inquiries that was undertaken, we know that this causes probably the most stress and distress to victims if there are delays in court proceedings. And so whilst there is certainly, without tying Labor into accepting this, but there is certainly an understanding where there is no reasonable excuse from a defendant. But what actually happened, what this bill does, is it does actually give the court the discretion to proceed in the defendant's absence where the defendant does not actually have or does have a reasonable excuse for not being there. Now that seems to actually be grossly unfair, Mr. Speaker, and that important principle of anybody being innocent until proven guilty, and the right to have a fair trial, that is something that we in Labor have a very, very serious concern about. The bill, Mr. Speaker, we would argue is, and certainly not inconsistent with the way this government does upgrade or change legislation. It's piecemeal again, and if the government had looked in a bigger picture way, Mr Speaker, and they could start by implementing the Law Commission's 2004 report, Delivering Justice for All.
Sorry to interrupt you.